to mention a matter from the list, serial number 83. In this matter, your leadership by order dated 20th February, the lower court records were called from the labor board. But since what has happened, that the file was kept pending in the courtroom and it didn't reach the section, due to which the lower of the
Why are you mentioning it?
because I so that the registering may be directed to call for the.
They will call for the record. They must have issued the letter.
Leadership
Please don't waste time in the morning. It will be taken up as and when the case is called.
From supplementary list of page filing item 1, WPS 1701 of 2023.
Mr. Connected ID.
Lecture 4, page 33 is the view order. The petitioner has been terminated on the basis of an order passed in WPS number 2072, wherein it has been held no fresh appointment can be made of chowkidars, as because there is a rule framed in the year 2015. Now we are that Nandal Logra has challenged that order in the Millard appeal. Millard, if not, will find paragraph 9 of this page 4. Herein also it has been held that no fresh appointment can be made. Now, Lord, here the petitioner has been appointed in the year 2019.
Date?
Lord, 2011, Lord, he has been appointed and reflected in the implement order itself. Lord.
Date of appointment?
21/11/2011.
Yes.
The appointment letter is also there. Lord. So, if my submission is that rule has been framed in the year 2015, so that rule cannot be given retrospective effect, and this division bench got this writ court order on the basis of which the termination order has been issued, that has been modified that no fresh appointment, so it has not been given retrospective effect. And the counter affidavit read entire reading with respect to the retrospective effect has not been replied.
That's all?
No, sir.
What do you have to say?
On the basis of judgment, Millard, in which Millard, the appointment of on the basis of hereditary and nature, Millard, has been deprecated by the Honorable Court, and on that basis, Millard, the impugn order has been passed.
Lord, only reply is short. If Lord hereditary, then they have to pass Lord that act was passed in 1957. And 1957 till 2015, there are lots of appointments.
That's
Why they are choosing only 2010 and 2011?
WPS number 1701 of 2023. Learned counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the petitioner, while referring to the impugned order, has submitted that the hereditary the petitioner was appointed on 21/11/2011 by virtue of hereditary right, and the petitioner has been the petitioner has been terminated by order dated 23/4/2016 by virtue of order passed in WPS number 2072 of 2007. The learned counsel further submits that the said judge now can be made to the post of chowkidar on the basis of inheritance only. The learned counsel further submits that the Honorable Division Bench has also taken into consideration the rules which have been framed in 2015, and the said rules cannot have any retrospective effect. The learned counsel submits that the judgment passed in LPA number 196 of 2012 was delivered on 9/8/2019. and therefore any appointment made prior to that date cannot be interfered with. The learned counsel appearing on behalf of the respondents, on the other hand, has opposed the prayer and has submitted that the LPA was dismissed and the impugned order has been passed pursuant to the order passed in WPS number 2072 of 2007, and therefore the impugned order does not call for any interference. He submits that the petitioner does not have any hereditary right of appointment, and such appointment has been held to be violative of Article 14 and 16 of the Constitution of India in the writ proceedings. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that it is not in dispute that the petitioner was appointed on 1/12/2011 by virtue of hereditary right,
Yes,
by
that
virtue
was
of
the act at that time, the rule also that.
by virtue of hereditary right. In WPS number 2072 of 2007, which was disposed of prior to his appointment on 21, which was disposed of prior to his appointment. Yes, in WPS number 2072 of 2007, disposed of on 17/11/2011, that is prior to the appointment of the petitioner, the following order has been passed. Upon perusal of the said judgment, this court finds that the writ court had specifically held that the appointment to Chowkidar has to be through public advertisement and after giving equal opportunity to all the eligible candidates, and there cannot be any right for appointment merely after the judgment dated 17/11/2011 and was certainly governed by the said judgment. Further, the said judgment passed in the writ court was subject matter of consideration in LPA number 196 of 2012 and analogous case, which has been ultimately disposed of by which has been ultimately dismissed by judgment dated 9/8/2019, and in the meantime, the rules framed in the year 2015 had also come into effect. Paragraph 9 of the aforesaid judgment is quoted as under. This court finds that the appeal against the judgment dated 17th November 2011 has been dismissed, and the direction issued by the writ court in judgment dated 17/11/2011 has not been interfered with. In view of the aforesaid facts and circumstances, the appointment of the petitioner having made after the judgment dated 17th November 2011, that is on 21/11/2011, cannot be sustained in the eyes of law. In view of the aforesaid facts and circumstances, the impugned order of termination of the petitioner does not call for any interference. Accordingly, this petition is hereby dismissed.
Item 2, WPS 1747 of 2023.
This case will also be for compassionate appointment, which was rejected by
husband was working as TR Cat 1, died on 2/2/2016. Information was duly given on 9/2/2016, and my claim was rejected by order dated 19/2/2018. Your Ladyship, in the impugn order, if I may be allowed to read.
Yes, what do you want to say from the impugn order?
Your Ladyship, the impugn order is passed in non-unjust ground. Your Ladyship has not considered anything whatever was.
No, it
there.
has
I
been
have
held to
made-
be time barred.
Your Ladyship, it was not time, but I have made the representation within time, due to which my name, the name of the husband was deleted from that, Your Ladyship. So the information was duly given that the husband of the petitioner died, Your Ladyship.
WPS number 1747 of 2023. The state petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the husband of the petitioner had expired on 2/2/2016, and the information regarding death was given on 9/2/2016, and pursuant thereto, the name of the husband of the petitioner was struck off from the roll. He submits that since the intimation regarding death was given within time, it cannot be said that the application for grant of compassionate appointment was barred by limitation. The learned counsel submits that the impugn order has been passed on the sole ground that the application was filed beyond the period prescribed, that is 1.5 years, and the application was filed only on 16/7/2017. The learned counsel has submitted that in such circumstances, the impugned order calls for interference, and impugned order is perverse and calls for interference. Are you opposing?
Yes.
Learned counsel for the respondents has opposed the prayer of the petitioner
In fact,
and has submitted that the intimation for about death of the husband is not an application for compassionate appointment.
in fact,
He has further submitted that in the impugned order, a lot of communication has been mentioned in asking the petitioner to apply for compassionate appointment. Those communications have not been disputed in the writ petition, but in spite of those communications, the petitioner did not take steps within the stipulated time, and consequently, the impugned order does not call for any interference. After hearing the learned counsel for the parties and considering the facts and circumstances of this case and the averments made in the writ petition, it is not in dispute that the husband of the petitioner died on 2/2/2016 while he was in the service of the respondents, and the petitioner had intimated, and the petitioner has served a letter dated 9/2/2016 as contained in Annexure 3, whereby and which has been as contained in Annexure 3, and upon perusal of the said document, it is apparent that it was only an intimation about the death of the husband of the petitioner. It further appears that pursuant to such intimation, the name of the husband of the petitioner was also deleted from the roll of the respondents by the order dated 9/3/2016. From the perusal of the impugned order dated 19/2/2018, it has been mentioned that the petitioner was informed time and again, including by letter number 4040 dated 31/3/2016, semicolon, letter number 959 dated 25/7/2016, semicolon, letter number 1418 dated 9/9/2016, semicolon, letter number 2837 dated 24/1/2017, and letter number 130 dated 16/4/2017, to ask the petitioner to apply for compassionate appointment for post-death benefit, but the petitioner did not apply within the time prescribed and under NCWA, and applied only on 16/7/2017, on account of which the impugned order has been passed by observing that the application having not been observing that the application was time barred. The communications which have been mentioned in Annexure 5 has not been annexed by the writ petitioner in the writ petition, nor it has been mentioned in the writ petition that these communications were never served upon the petitioner. This court finds that the grant of compassionate appointment is not a matter of right, and the same is governed strictly in terms of the scheme for compassionate appointment. It is not the case of the petitioner that in such circumstances, this court finds no perversity or illegality in the impugned order, which is hereby dismissed. However, since the petitioner claims to be the wife of the deceased employee, she would be entitled for monetary compensation as per the applicable norms of the respondent.
Yes,
Right?
yes.
How much time will you need to do that? At this counsel,
6
further
weeks.
respondents has submitted that.
If the petitioner applies, we will take a decision
That,
within 6 weeks.
has submitted that if the petitioner applies, appropriate order will be passed within a period of 6 weeks from the date of the
Yes.
application. It is expected, accordingly, though this court is not inclined to grant the relief as prayed for in this writ petition, but entitlement of monetary benefit, monetary compensation is certainly to be considered by the respondents.
Yes.
The petitioner shall approach before respondent number.
Let it be for the general manager.
Respondent number 4, by filing a representation claiming monetary compensation in lieu of compassionate appointment. Upon such application, the respondent number 4 shall verify the records and pass appropriate order, and if the petitioner is found entitled, the steps be taken so that the amount is remitted in the account of the petitioner. The needful be done within a period. I'll just give a time frame.
Yes. Only one correction, Lordship. The date of application was 16/9/17. Your Lordship said 16th July.
Okay, 16/9/17 was the date of application.
Item 3, WPS 1748 of 2023.
Date of death
26/10/2016.
2000.
Date of death is 26/10/2016.
2006.
6.
Yes. What are you claiming?
Related quashing of order at Annexure 6 relationship. It has been rejected that my claim is time barred and my name does not appear in the service book.
So you need succession certificate.
Related that I have a on the same ground that the investigations would have been made by the respondent authority that being the beneficiary provision relationship, the benefits shall be given.
You go and get
On the
succession
only-
certificate.
Only
You
on
will
the
get the.
basis-
You see, there is a provision under law. Your name is not appearing in the service records. You go and get succession certificate.
It is not in dispute that I am not the wife.
We do not know. Who will dispute it?
Your Ladyship, for
They
that,
are governed. They are governed by their own records, right? If it is not in dispute, they will give it to you. We don't know anything. They have simply said that your name is not appearing in the service record, and they have rejected it. So you go and get your succession. You will get it, irrespective of whatever be the amount of delay. Right? Delay will not take away your rights. Is that okay? Delay should not take away her post-death rights. Right? When did the person expire?
26/10/2006.
26 अक्टूबर 2006.
The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner submits that the husband of the petitioner had expired while in service of the respondents on 26/10/2006. But by the impugned order, the service benefits has been denied to the widow of ex-employee by recording that there has been inordinate delay in making an application, and further the service linked records of the ex-employee does not reflect the name of the petitioner and her children. as which was required to be disclosed by the ex-employee, right? The learned counsel for the petitioner has submitted that the aforesaid ground is not tenable in the eyes of law, and accordingly the impugned order calls for interference. The learned counsel appearing on behalf of the respondents has submitted that since the name of the petitioner and her children do not appear in the service record, therefore the impugned order does not call for any interference. The petitioner may have to obtain a succession certificate to claim any relief. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, the petitioner claims that her husband, namely Nageshwar Mehto, was appointed in Central Coalfields Limited and was working as Mazdoor Category 1 in Govindpur project Kathara area. And he died on 26/10/2006 while in service. The petitioner claims to be the wife of the ex-employee and has one son and one daughter in the family. The petitioner, however, when the petitioner applied for service benefits, the same has been rejected on the ground of delay, as well as observing that the service linked record of the ex-employee does not reflect the name of the petitioner and children. This court is of the considered view that mere delay will not defeat the right of the petitioner to get benefit of petitioner and her children to get death benefits of Nageshwar Mehto, but the fact remains that the name of the petitioner and her children does not reflect in the service linked records. In such circumstances, this court is of the considered view that in order to claim any benefit, any post-death benefit, the petitioner will have to obtain a succession certificate from the competent court of law, and her claim can be considered only upon production of succession certificate. This petition is accordingly disposed of.
Item 4, WPS 3452 of 2023.
Regarding leave encashment relationship earned till 15/5/2001. The petitioners were appointed in adult education scheme. Thereafter, their employment was absorbed and the service rendered in the past services.
You were in minority school.
You were adult education school.
It's not a minority school. This Mariam Tirki is a case of minority institutions.
But
So you have been, you claim that you have been regularized. Absorbed or regularized?
Absorbed.
Your appointment letters are not on record. But at the same time, you say that others have been given benefit.
Policy decision has also been taken by the government.
Where is that policy decision? So according to this policy decision, you are entitled for the differential payment.
The leave encashment for that part.
For the previous, that is, you have got for only for 148 days leave. Okay. We'll dispose of. He claims that it is as per. We are not pronouncing that he is entitled. You do it. Who
He
will?
can-
But this time
They can
the matter
represent-
has to be taken up by the respondent number 2.
Yes.
2 or 3?
Leadership, it must be 3 village.
3.
The director.
Yes. Because it is going to affect many persons.
Absolutely.
The learned counsel for the parties are present. This writ petition has been filed for the following relief. The petitioners claim that they were appointed on the following post under adult education scheme. Para 4 में you will get a chart. It has been further submitted that subsequently adult education scheme was closed by the government with effect from 16/5/2001, but the services of the petitioners and other similarly situated employees were not terminated, and after much litigation, the state of Jharkhand resolved the problem by memo number 824 dated 30/5/2007 that the services of the petitioners and other employees will be absorbed in different departments and posts held by such persons will be absorbed. In the light of the state policy decision, the petitioner claims that they were absorbed in +2 schools. The details has been mentioned in paragraph 6. However, the date of absorption of the petitioner has not been mentioned in the writ petition. The petitioner further submits that the petitioners attained the age of superannuation on various dates. The dates with regard to each of the petitioner has been given in paragraph 8. The learned counsel has referred to paragraph 10, 11, 10 to 15 of the writ petition to submit that by different memos, the petitioners were given only part payment of their total entitlement of leave encashment. The said paragraphs are quoted as under. ये सारा paragraph quote कर दीजिए. It is the case of the petitioner in paragraph 16 that as per the sanction order, leave encashment has been granted by only considering their duties from 35/2007, that is after their absorption in service. The learned counsel for the petitioner has submitted that other similarly situated persons have been given the benefit of past service, and the respondents have now come up with a circular dated 10/1/2023 issued by the Director Primary Education Jharkhand Ranchi, and as per the said circular, the petitioner would be entitled for leave encashment for a total period of 300 days, irrespective of their date of absorption on 35/2007. Right? The learned counsel for the respondents has submitted that no counter affidavit as such has been filed in the present case, but the claim of the petitioner can be considered by respondent number 3 in the light of applicable circulars. Right? Yes.
It is not a circular leadership, it is an
Decision,
order.
whatever.
Order taken
Whatever
in
it
light
is.
of the
That's
order passed by the Honorable Court.
Circular or order or decision. Circular/order/decision. After hearing the learned counsel for the parties and going through the aforesaid submissions based on the materials available on record. This court finds that the petitioners now claim that a decision has been taken by the Director Secondary Education to grant the benefit of leave encashment for total period of to grant the benefit as claimed by the petitioner. In such circumstances, this writ petition is disposed of, enabling the petitioner to approach respondent number 3, who shall consider the grievance of the petitioner with regard to their claim of differential leave encashment in the light of the applicable circulars / decision of the state government, and also any other material which may be relied upon by the petitioner. The petitioner shall file a detailed representation before respondent number 3 within a period of 15 days from today. Upon filing of such representation, the respondent number 3 shall grant an opportunity of hearing, pass a reasoned order, baki ek general time.
Just for
If the petitioner is found entitled to benefit under entitled to any monetary benefit, appropriate steps be taken so that the monetary benefit is also credited to the account of the petitioner within the period of 3 months from the date of the reasoned order. Reasoned order will be communicated to the petitioner through speed post. It is made clear that this court has not entered into the entitlement of the petitioners, and it will be for the respondent number 3 to pass appropriate order as in accordance.
My ladyship, if I understand correctly, it should be respondent number 4, Director of Primary Education.
Respondent number 4?
4 minutes.
Okay, respondent number 4. That's all?
My ladyship. All right.
Item 5, WPS 4350 of 2023.
In which district did you apply?
So Bokaro,
This in the district of Bokaro? Learned counsel for the parties are present. District petition has been filed for the following relief. The learned counsel for the petitioner submits that the petitioner had applied for appointment of para teacher pursuant to advertisement issued by the respondents. Advertisement का number नहीं लिखा. Advertisement number.
They have stated in paragraph number 8 of the their rate of application advertisement number 4
it was through letter number 180, there are 8 numbers,
Just
and advertisement number is 4.
advertisement number 4 of
15
2015-16. The learned counsel further submits that the petitioners were working as para teacher and they had applied under non-para category. The petitioner, single petitioner. He has further referred to paragraph 10 of the writ petition to submit that the petitioner was the petitioner was not allowed to participate in the counselling by the members of counselling team on the ground that the petitioner, being a para teacher, could not have applied in non-para category, and the members of the counselling team as well as District Superintendent of Education demanded his resignation from the post of para teacher. Then only the petitioner can be allowed for counselling in non-para category, and thus showed the petitioner as absent. The learned counsel submits that the matter regarding entitlement of para teachers applying under non-para category was subject matter of consideration in various writ petitions, including which were also subject matter of appeal, including in LPA number 186 of 2017, wherein it has been held that the para teachers can apply under non-para teacher category if they are not claiming any reservation under para teacher category. The learned counsel has also submitted that. Thereafter, on account of various irregularities in the matter of counselling and considering the available vacancies, a batch of writ petition was disposed of in WPS number 2142 of 2019. नहीं ऐसा लिखिए. The learned counsel submits that after the judgment passed in LP number 186 of 2017, dated 11/5/2018, another writ petition being WPS number 2142 of 2019 and other analogous cases was disposed of by this court by order dated 13/5/2019, wherein it was observed that in the counselling process, wherein it was observed that as per the litigation policy of the state, if a person is entitled to get benefit out of an issue which has been decided, even if he had not approached the court, he is entitled to get the same benefit. The learned counsel submits that although the petitioner never approached this, did not file any writ petition before this court, but the benefit of LPA number 186 of 2017 was required to be extended to the petitioner. He has also submitted that a batch of writ petitions was disposed of by this court in WPS number 2378 of 2019 on 16/2/2022, and a direction has been issued for fresh counselling. The said judgment was subject matter of consideration in LP number 203 2022, which has been disposed of with appropriate directions on 15/9/2023. And another batch of LPA arising out of the same judgment passed in WPS number 2378 of 2019 and other analogous cases has been disposed of by the order by judgment dated 31/1/2024. LPA number 510 of
2023 and connected
2023 and analogous cases. The learned counsel submits that similar order may be passed in the present case also. The learned counsel, appearing on behalf of the respondents while opposing the prayer of the petitioner, has submitted that the petitioner was not called for, that the statement made in paragraph 10 of the writ petition that the petitioner was asked to resign and was not permitted to participate in the council has been denied in paragraph 12 of the counter affidavit by stating that the petitioner has not submitted any document in support of the same. The learned counsel submits that in fact the petitioner was never called for counselling in view of the fact that the name of the petitioner did not fall within the zone of consideration. And this is apparent from Annexure A at page number 12 of the counter affidavit. That's all. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that it is not in dispute that this court finds that the petitioner claims to have applied. Petitioner, being non-para teacher, claims to have applied for under para teacher category in the district of Bokaro.
Non-para category, being para.
Applied under non-para category in the district of Bokaro. It is further not in dispute that the eligibility of such persons was subject matter of consideration in LPA number 186 of 2017, which was and it was held that there was no legal impediment in making application by para teachers in non-para category. However, from the order annexed at Annexure A, page number 12 of the counter affidavit, it appears that one of the reasons for it appears that two grounds have been mentioned in the said order. One is that the petitioner was not a party in LPA number 186 of 2017 with LPA number 199 of 2017, and the other is that the petitioner was never called for counselling. This court finds that irrespective of the fact as to whether the petitioner was party in LPA number 186 and of 2017 and other analogous cases has ultimately been taken care of by this court in WP
2142.
S number 2142 of 2019 as referred to by the learned counsel for the petitioner during his course of argument. And so far as the other reason that the petitioner was not called for counselling as his marks was much below the cutoff marks is concerned, the same reflects that the respondents have never called the petitioner for counselling, right? In such circumstances, this court also finds that in order to fill up the remaining vacancy, one counselling has been directed by this court in the aforesaid batch of LPS, wherein following directions has been passed. Accordingly, this writ petition is disposed of in with the same directions, and then you will have a follow-up order.
Yes.
That's it. हम लोगों ने एक केस में एक उसको कोट किया जो सुबह भेजे थे ना, उनको नंबर बता दीजिए, उसी से कोट कर लेना है। Writ का, right? This writ petition is accordingly disposed of. उसमें कुछ डायरेक्शंस है, सेम डायरेक्शंस में।
Item 6, WPS 6915 of 2023.
Yes, petition. Yes, respondent.
Yes, Your Lordship.
You are giving the benefit to other persons.
Not giving the Lordship, just saying that single district person had been given, so they may be asked to give representation for the responding parties, considering all the
That's
district petitions.
Respond number 3.
Yes, Your Lordship.
The learned counsel for the parties are present. This writ petition has been filed for the following relief. the learned counsel for the petitioner has submitted that the petitioner number 1 was appointed on the post of assistant teacher primary school Pandya Pandey D by letter dated 4/4/1976. Petitioner number 2 was you mix up all the authorities.
No,
It is in the same district,
same. Jamtara.
all under Jamtara, DSC Jamtara. No, DSC Santhal Pargana Division Dumka, petitioner number 1.
Earlier, the appointment was Dumka and Jamtara, Dumka district Santhal Pargana was there.
Okay,
Subsequently,
all right. Petitioner number 2 was appointed by appointment letter dated 25/7/1976. Petitioner number 3 was appointed by appointment letter dated 5/4/1976. And petitioner number 4 was appointed by the appointment letter dated 25/7/1976. In the writ petition, averments have been made, but the letters of appointment of the petitioners have not been annexed. Such averments have been made from paragraph number 6 to 9 of the writ petition. It is further case of the petitioner that they were appointed on metric trained scale and their pay scale was fixed by memo dated 24/1977 on the scale of rupees 230-6-340 with effect from 1/4/1977. The petitioner number 1 was granted first time-bound promotion on 1/4/1976 instead of 15/4/86. Petitioner number 2 was granted was granted on 1/4/1987 instead of 12/6/86. The husband of petitioner number 3 was granted the benefit on 1/4/1987 instead of 17/4/86, and the petitioner number 4 was granted first time bound promotion on 1/4/1987 instead of 12/6/1986. And all of them were granted first time bound promotion taking into consideration the date of granting metric trained scale. But their date was not considered, was not calculated from the date of their appointment/joining. It is the case of the petitioners that the time-bound promotion ought to have been considered from the date of their joining and not from the date of grant of metric trained scale. It is further case of the petitioners that by the same appointment letter, similarly situated persons were also appointed and their date of time-bound promotion has been corrected by memo dated 5/7/2022 as contained in Annexure 1 which was the learned counsel further submits that the the Learned Council has also relied upon the government letter dated 1147 dated 17/6/1995 issued by Government of Bihar in pursuant to the order passed in writ petition being CWJC number 5251 of 1990 passed by Honorable Patna High Court. He has further submitted that a letter number 132 dated 18/1/2002 was also issued by the government to the District Superintendent of Education Jamtara to take into consideration the initial date of appointment for grant of time bound promotion to the assistant teachers. The Learned Council submits that. Similarly, situated teachers have been granted the benefit, but the same benefit has not been granted to the petitioner, in spite of the fact that the petitioners have represented
Yes, ma'am.
before the respondent number before the District Superintendent of Education Jamtara. And consequently, the present writ petition has been filed. The Learned Council for the respondents has submitted that, though no counter affidavit has been filed in the present case, but considering the averments made in the writ petition, the grievance of the petitioner can be considered by respondent number. Respondent number 3. Respondent number 3.
Previous representations were given to DSC lordship.
DSC
several
we will not ask DSC to
Yes, yes.
answer. We will ask the director to
Yes,
answer.
yes.
Can be considered by respondent number 3, as such issue will have impact for the entire state of Jharkhand. After hearing the Learned Council for the parties and going through the aforesaid averments which has been made after hearing the Learned Council for the parties and considering the averments made by the petitioners in the writ petition, this court is of the considered view that the matter is required to be considered at the first instance by respondent number 3. No adverse order has been placed on record by the petitioners, and the petitioners are seeking a mandamus from this court.
One order they have annexed at page 46. There's a similar situation had already been dealt
That's
by
right,
appointment.
Everything will be taken care of.
Yes.
We don't want to say anything more. Accordingly, this writ petition is disposed of, enabling the petitioners to file their separate representations. You file your separate representations with supporting documents before the respondent number 3 within a period of 4 weeks from today. The petitioners may jointly file, are directed to file one set of writ petition jointly. You just file one set of writ petition. Representation should be separate, but one set of writ petition should be enough. Upon filing of such representation, the respondent number 3 shall get the facts verified from the concerned District Superintendent of Education and pass a reasoned order after granting an opportunity of hearing to the petitioner. Within a period of 4 months from the date of such representation. If the petitioners are found entitled for the reasoned order be communicated to the petitioner through speed post. If the petitioners are found entitled for any benefit arising out of the reasoned order, the same be also conferred upon the petitioner within a period of 3 months from the date of the reasoned order. It is observed that the present that it is for the respondent number 3 to take care of all the applicable circular and judgments as may be produced by the petitioner and as may be applicable to the petitioners. Yes, petition is accordingly disposed of.
Item 7, WPS 6956 of 2023.
The only ground that he is an illegitimate child born out of second marriage.
Can we see the initial age first for the counter?
H.
Relevant para page 81. Married person.
Yes.
पुलिस निरीक्षक जगदेव भगत के मरणोपरांत वर्षा भगत सिंह द्वारा दायर याचिका में माननीय न्यायालय सोरेनसो को पारित एक पक्षीय आदेश का उल्लंघन किया गया है। श्रीमती वर्षा भगत सिंह के कथनानुसार इनकी शादी दिनांक 8 नवंबर 2002 को इनके मायके के परिवार वालों की सहमति से जगदेव भगत से हुई है, लेकिन इनके द्वारा विवाह संबंधी कोई साक्ष्य प्रमाण उपलब्ध नहीं कराया गया। फर्दर विदित है कि जो हिंदू विवाह अधिनियम 1955 का जो प्रोविजन है कि ड्यूरिंग फर्स्ट वाइफ दूसरी वाइफ से आप दूसरी वाइफ को नहीं रख सकते हैं, दैट कैन नॉट बी अ वैलिड मैरिज। एंड थर्ड लॉर्डशिप जो एक प्रोविजन है झारखंड पुलिस मैनुअल का 707A1 वो भी कहता है कि आपको नहीं कर सकते, काइंडली उसको देखा जा सकता है।
शादी नहीं कर सकते, there is no doubt. What about the child? Child को डस्टबिन में फेंक दें? Possible?
That is the ground has been taken up.
That is the only ground. Because you have conducted your inquiries, right? And you say that as per the Janch Prativedan, there was a marriage, there was a second marriage, right?
That has been concealed.
Maybe the employee has concealed it. And had he disclosed it, he would have been dismissed. Those things are very different.
And another thing, also during first marriage, the deceased employee has done second marriage.
That's right. Illegal marriage. Second marriage here is an illegal marriage. But what about this judgment of Supreme Court? This one? Page number 59 of the writ petition. Was this a judgment arising out of an illegal marriage? Had two wives.
Yes.
In his lifetime, he had two wives. This is the fact of the case, right? And there was a negative covenant in the railway circular. That has been quashed and set aside. And you don't have any negative covenant also. The right of a illegitimate child, how can that be denied? This is the only ground for denial. And now that second wife is also not there. She never had any children.
First has no children.
First wife had no children.
And she is overage also, 66.
Maybe she is not claiming, she is not the
She is
claimant.
not claiming.
She may be entitled for post-death benefits.
Yes.
But when it comes to compassionate appointment, you will maintain the first wife also.
But,
You are bound to. You are seeking compassionate appointment, subject to her available source of livelihood. You can't run away from that.
yes.
You will have to maintain both your mothers. You'll have to take care of her. You are seeking compassionate appointment. maybe that your biological mother may not be entitled to any post-death benefits. But the first wife will get the post-death benefits, maybe pension or whatever.
She made application only for benefit, that benefit, the post-retirement benefit.
That must have been given to her. But you are undertaking to maintain your both the mothers has to be there, because that is a ground for grant of non-marital department. Isn't it? You take the affidavit. Do you take the affidavit or you don't?
Lordship, as I know, Lordship, that is a ground. That is a ground during providing compensation ground. Then the person who seeking appointment, that person has to be
Undertaking
that I will serve.
But one thing may submit, during lifetime of the husband, my lord, husband has filed divorce suit, although that is the ex parte order, and that order has never challenged by the first wife, any court of law. It has come in the inquiry report.
the divorce suit was decreed during her lifetime.
Yes.
During his lifetime.
Yes, sir. They also brought on record.
What is the date of death?
Date of death, my lord.
And what is the date of decree?
Date of 18th April 2021.
Date of death. There is a divorce also.
Yes, Lord.
She cannot even claim post-retirement benefits. She will not be entitled to anything because there is already a divorce. Maybe that there is an order of permanent alimony in the divorce. We do not know. There could be.
But so far as retirement benefit is concerned, except the compassionate appointment also, because the records of the deceased employee shows only the name of first wife.
He would not have disclosed, no. Because had he disclosed, he would have been immediately dismissed from service. Isn't it? But your inquiry report is saying that there was a second marriage performed in 2002.
Yes.
And you say that while the first wife was alive, he performed a second marriage. And therefore you have rejected the claim of the petitioner.
And the report of CO also says also, is on page number 76 of counter.
You will go only by the impugned order. What's your report?
Lordship, as per the petitioner's mother, Lordship, earlier they have not informed that there is a wife of the deceased person, Lordship, and therefore they got a certificate from the CO. Thereafter, the answering respondent again prayed to CO to conduct an inquiry, and inquiry has been done, and this report is.
And that report.
And therefore the impugned order,
Lordship.
based on whatever inquiry you wanted.
Lordship.
Even in the inquiry report, you say that your ground is that there was a second marriage during the lifetime of the first wife, and divorce was taken subsequently. That is it. What proof do you expect from these people of marriage? You have conducted your inquiry. You have been there. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the father of the petitioner, namely Jagdev Bhagat, was in service of the respondents, and he died in harness on 18/4/2021. Leaving behind his widow, namely Varsha Bhagat Singh, and two sons, namely Aditya Kumar Barik, aged 18 years, and Nitin Krishnan Barik, aged 13 years, and one daughter, namely Asha Barik, aged 17 years. The learned counsel submits that Varsha Bhagat Singh is the mother of the petitioner.
Mother.
The learned counsel further submits that the petitioner is a matriculate You have annexed a matriculation certificate?
Yes.
Where is it?
That is page 38.
Aditya Kumar Barai, Mother Barsa Bhagat, Father Jagdev Bhagat. Council for Indian School of Certificate Exams in India. Secondary school.
But you had not completed 18 years on the date of death. You were still minor. We will, that is not the ground they will consider it. We will not say anything on that. They have a circular of 5 years also. So I will not pronounce on that. This is it. The petitioner was born on 13/4/2005 as per the matriculation certificate annexed with the writ petition. He also submits that the father of the petitioner was earlier married with one Bailey Baraik. Respond number 5.
Yes.
You have made respond number
Yes.
5 also.
There was no issue and it has come from the
Bailey Baraik, but she had no issue and arising out of a divorce suit filed by the husband, by the ex-employee bearing MM case number 11 of 2006. The same has been decreed by judgment dated 10/2/2014. While the father of the petitioner was alive and in service. The learned counsel submits that a writ petition was filed by the that should not be sufficient. That should be sufficient. The learned counsel submits that the petitioner had applied for compassionate appointment. But by the impugned order dated 16/11/2023, the compassionate appointment has been declined only on account of the reason that the mother of the petitioner was the second wife during the lifetime of during the subsistence of the first marriage. The learned counsel submits that as per the impugned order, which was passed upon due inquiry, the the biological mother of the petitioner, namely Varsha Bhagat Singh, was married to the ex-employee on 8/11/2002. And the first marriage with Albeli Kumari alias Beli Badaik was conducted in the year 1990. But no issue was born out of the first marriage. The Learned Council submits that, irrespective of the fact that the second marriage with the biological mother of the petitioner of the ex-employee was performed during the lifetime of during the subsistence of the first marriage, the petitioner at best would be an illegitimate child born out of second marriage, right?
Child are not illegitimate. Child are legitimate.
Okay. Is a child, we will not use that word, is a child born out of second marriage, and his right cannot be taken away. The Learned Council has further referred to the judgment passed by the Honorable Supreme Court in civil appeal arising out of SLP civil number 18571 of 2018, within bracket Mukesh Kumar and another versus Union of India and others, and has submitted that in the said case, a condition was imposed by Railway Board. The condition imposed by Railway Board circular that compassionate appointment cannot be granted to children born from the second wife of deceased employee was under challenge. And the Honorable Supreme Court arrived at a conclusion that where is the finding?
Para 11. Governed by the judgment of Union of India versus DR Tripathi and consequently judgment order dated 18/2018 High Court Judicial Patna Gayatri Devi versus satisfied.
The learned,
That the appellant was Manish
just a
Kumar.
moment, the learned counsel for the petitioner has submitted that the Honorable Supreme Court has observed that though the law has regarded a child born from a second marriage as legitimate, the learned counsel has relied upon paragraph 15 of the said judgment, page 77, internal page 10. To submit that exclusion of a child born from second marriage for the purposes of compassionate appointment has been held to be impermissible. It has been further held that to deny compassionate appointment, though the law treats a child of a void marriage as legitimate, is deeply offensive to their dignity and is offensive to the constitutional guarantee against discrimination. The Learned Council submits that the ground to reject the candidature of the petitioner for compassionate appointment is perverse and contrary to the judgment pronounced by the Honorable Supreme Court annexed with the writ petition, and therefore the impugned order calls for interference. At this, the Learned Counsel for the respondents has opposed the prayer and has submitted that the petitioner would be entitled for compassionate appointment only as per the applicable scheme. And even if the ground which has been mentioned in the impugned order is set aside, then also the respondents would be entitled to examine the claim of the petitioner as per applicable scheme. Right? After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case and going through the impugned order as contained in Annexure 7 to the writ petition, it appears that the same has been passed pursuant to Annexure 8 of the writ petition. It appears that the same has been passed pursuant to order passed by this court in WPS number 3320 of 2023, dated 29/2023, wherein the writ petition was disposed of with a direction to the respondent number 4 to consider and dispose of the claim of the petitioner for compassionate appointment by passing a speaking and reasoned order within a time frame. It further appears that pursuant to such order, detailed enquiry on the spot was conducted by the respondents, and it came to light that the deceased employee had two wives, one namely Alveli Kumari of Beli Badaik, with whom the employee had a wedding, had marriage in 1990, and while the subsistence of the marriage, the second marriage was performed with the biological mother of the petitioner on 8/11/2002. And 3 children were born out of the second marriage. The first wife did not have any issue. It further appears from the impugned order that during the lifetime of the ex-employee, an ex parte order of divorce has been passed by the court of Principal Judge Gopalganj in case number 11 of 2006, dated 10/2/2014, and the marriage has been dissolved. आप लगाए हैं डिग्री?
हाँ, ये काउंटर में भी इनका इंक्वायरी में भी है।
डिग्री में कोई कॉमन एलिमेंट है?
नहीं, कुछ नहीं है इसमें। इनको पेपर पब्लिकेशन नोटिस वगैरह सारा।
Anyways, we are not concerned with that.
साक्ष्यों के आधार।
However, nothing has been brought on record to suggest that the said order of dissolution of marriage has been challenged or set aside by any competent court of law. This court finds that the impugned order has been passed by referring to the provision of police manual that during the lifetime of first wife, the second marriage is not permissible. And it appears that the performance of second marriage was not intimated to the respondents by the ex-employee during his lifetime. However, the fact remains that so far as the present petitioner is concerned, he is at best son born out of a void marriage. This court finds that in the judgment passed by the Honorable Supreme Court, in Mukesh Kumar and Another versus Union of India, ये अलग है दूसरा?
हाँ दूसरा भैया त्रिपाठी उसका इसमें रेफरेंस है यूनियन ऑफ इंडिया वर्सेस भैया
decided on 24th February 2022. Which in turn has referred to the earlier judgment passed in Civil Appeal number 12015 of 2018, decided on 11th of December 2018. In the said decisions of the Honorable Supreme Court, in the case of Mukesh Kumar and Another versus Union of India, the issue for consideration was, quote, whether the condition imposed by Railway Board circular that compassionate appointment cannot be granted to children born from second wife of a deceased employee is legally sustainable. Inverted commas. The Honorable Supreme Court, while deciding the case, have agreed with the counsel for the appellant that the issue was covered by the judgment of the Honorable Supreme Court in the case of Union of India versus B.R. Tripathi, wherein it was held that such a denial is discriminatory being only on the ground of descent under Article 16(2) of the Constitution of India. In the judgment passed by the Honorable Supreme Court, in Civil Appeal number 12015 of 2018, within brackets Union of India versus B.R. Tripathi, the findings of the Honorable Division Bench, as recorded in paragraph 12 to 15, (1 to 16) are as under. (1 to 18) is as under. Upon perusal of the said judgment, this court finds that the Honorable Supreme Court has clearly held that considering the purpose and object of a scheme for compassionate appointment, once the law has treated such children as legitimate, it would be impossible to exclude them from being considered for compassionate appointment. Children do not choose parents. To deny compassionate appointment, though the law treats a child of a void marriage as legitimate, is deeply offensive to their dignity and is offensive to the constitutional guarantee against discrimination. In view of the ratio laid down by the Honorable Supreme Court in their proceed judgments annexed with the petition, this court is of the considered view that the impugned order dated contained in memo number 99 dated 16/11/2023, refusing to grant compassionate appointment to the petitioner merely on the ground that the petitioner has been born out of second marriage of the ex-employee during the subsistence of the first marriage is cannot be sustained in the eyes of law, which is accordingly satisfied. However, it is for the respondents to scrutinize the application of the petitioner for grant of compassionate appointment as per applicable circular. Therefore, the matter is now remitted back to who will consider it? The same authority? Respondent number 4. Who is the respondent?
Superintendent, respondent number 4.
Respondent number 4 for passing a fresh order after granting an opportunity of hearing to the petitioner, and if the petitioner is otherwise found entitled for grant of compassionate appointment in terms of the applicable scheme, the compassionate appointment be granted to the petitioner within a period of 3 months from the date of production of a copy of this order along with the writ records. In case the petitioner is not entitled for any such relief, a reasoned order be passed after granting an opportunity of hearing to the petitioner and within the aforesaid time frame, and the reasoned order be communicated to the petitioner to speak first.
One thing also may be observed, when the mother of the petitioner is asked to produce the marriage certificate or whatever evidence, she was failed to produce.
Okay. The learned counsel for the respondents had submitted that the mother of the petitioner could not produce any marriage certificate in support of the marriage
Or any evidence like
or any evidence to that effect. The said submission of the learned counsel for the respondents is rejected in view of the fact that the respondents have conducted the necessary inquiry before passing the impugned order. And the only ground for rejection of the claim of the petitioner is that he was born out of second marriage of the ex-employee who performed the second marriage during the lifetime of, during the subsistence of the first wife.
Item for admission, item 8, WPS 6447 of the 2023.
Yes, petitioner. It's the same thing, Mr. It is the same thing.
Item 8.
Whose case is this? Your case? Same order which we have passed in the other case?
Yes, same order.
Same order?
Same order, same order. Same reading.
Same really?
Same reading.
Which was that number?
Just WPS 6915.
Serial number.
Serial number 6.
Serial number 6. Serial number 6 का dictation कौन है? Is there? विनीत जी, serial number 6 में जो dictation लिया है ना, identical case है. This is serial number.
This is serial number 8.
Serial number 8. First you get that corrected and then this order. We have just asked you to consider the representation and verify the records and pass them. इनका appearance record.
I'm preparing for respondent number 7.
Respondent number 7.
Accountant general. Because
You have anything to say?
No, we have filed a
We have
complaint. We have said that it's a departmental matter. Only
That's
if
right. No problem. Kindly note their appearances. दोनों केस में अलग है. Petitioner same है, respondent अलग.
From daily list for final disclosure item 1, WPS 305 of 2023.
May I please, Your Worship?
Lordship, in this matter, rejoinder to our supplementary affidavit has been filed on 28th February. Today only I have received the copy of it, Lordship. It may be kept tomorrow or any day, Lordship. We will go through.
You have filed your list of dates?
There are only two annexures, Your Worship. But if Your Worship so desire, I can file it.
That helps me to give the dictation.
I will do that.
Online dictation, we have to be very careful.
I'll do that.
The learned counsel for the parties are present. The learned counsel for the respondents seeks adjournment to go through the rejoinder. The matter is adjourned and directed to be posted on next Tuesday. In the meantime, by Friday, the counsel for the parties are directed to file short synopsis, list of dates, and copies of the judgment which is seek to review. You do it by Friday.
Item 2, WPS paper 4 of 2023.
Lordship, this pointer is actually we could not able to check it, Lordship. We have
It's
given,
ready.
Yes, Lordship, we have given the pointer to the respondents.
Okay. What is your rejoinder? Give it, we will decide it right.
I was seeking indulgence. There was a direction to bring on record any application which has been made on basis of which the PS2 and PS3 form. That instructions we have. Only one indulgence I am seeking on that regard. And we have to go through the rejoinder as it was served only yesterday.
So you must have filed your counter affidavit after the last order.
We have filed the counter affidavit here and there was a direction to file rejoinder and leadership seeked instruction on the point that we are stating that he himself made corrections to the PS2 and PS3 form wherein he entered a different date of birth which he is claiming before your that and on that record, leadership directed me to bring on record any basis on which that correction was made, any application or any.
I have asked you to produce the records.
Leadership. Only
Where
for
is it?
only for that only I am seeking.
You file
on
your
record.
counter affidavit and you do not retain the records.
Leadership, we got on record the PS2 and PS3 forms.
No,
wherein the
you
correction-
were directed to produce the records. We will see it from the records only.
I'll ask for the
Why do you
record.
need a further affidavit?
We'll bring on. It was my.
He has been made to retire earlier, no? He has already attained the age of superannuation.
That is his claim.
10 months before.
I'll get the records later. All the entire original records. It was our understanding that we'll need to file that record.
You see, the practice of seeking adjournment when the case is called out and without giving any advance notice for adjournment is not appreciated by me.
I apologize for that.
Because at the cost of your case, at the cost of other cases, we read your brief and you seek adjournment.
I apologize. In the future,
You bring it Monday को कितना केस है final disposal में बताइए? Wednesday.
Next week, Wednesday, 4 cases.
We are posting it on next Wednesday. You produce the records. You are filing the rejoinder. Are you filing the rejoinder?
Yes, Lord.
Okay.
It may be accepted, Lordship.
WPS number 444 of 2023. Rejoinder to the counter affidavit is filed during the court proceedings which is taken on record. Learned counsel for the respondents pray for adjournment to produce the connected records in terms of the last order. Post this case under the same heading on next Wednesday. No further adjournment will be granted.
Item 3, WPS 1361 of 2023.
In this case also, records of there are some corrections I have made. The records were called by order dated 3rd of January 2024. To check what the date of birth of the petitioner was entered into the service record. Form B was called for. And this is the gist of my argument also.
You have filed, the form B is there?
Leadership, on that we have filed a supplementary affidavit stating Form B is a statutory form which is made only for the person who have been posted in the mines. This particular petitioner has never been posted in mines his entire career.
Therefore, it is not there.
It will not be there. Leadership.
Do you have anything Form B? Have you stated anything about Form B?
This there is my lady kindly see their annexure that they have annexed to the supplementary affidavit. They have also not annexed service record. They say that one of the documents extracted from the service book is being brought on record. Annexure C.
You produce the records, please.
I will bring
on next Wednesday.
Let it go.
The learned counsel for the parties are present. Considering the nature of controversy involved in the present case, the learned counsel for the respondents are directed to produce the records, connected records, on next Wednesday. Post this case on next Wednesday. Date is where, or you just whatever you produce, when you produce the records, prepare at least one copy for the court, so that you both of you can share, and then we have a copy.
I'll get the copies also and the entire original records.
Item 4, WPS 1657 of 2023.
Also might have gone through the written notice of argument that there is a slight correction, that is a mistake done by my junior also, I accepted mine.
What correction?
In place of Jharkhand
इसको
pension.
जरा आप करके दो.
जी.
Where is the other side?
Jharkhand pension.
Respondent. Respondent is absent.
Very small matter also, the rejection order of my regularization, wherein they have accepted everything that there is a advertisement, there is a interview, the selection process, appointed against the sanction and vacant post. But since this department and their appointment is not illegal, even they have said in the impugned order, the appointment is not even illegal. But this department cannot regularize them in terms of Rule 2015.
Where is the impugned order?
Lordship, Annexure 5 at Annexure 6 at page 49, Lordship. Lordship, got it. Now next page 50. The relevant Lordship, I will read from last paragraph, Kandika 2, if Lordship permits.
Kandika 3.
Kandika 3, Lordship.
This is the order.
Yes, Lordship. Type
In
of
all your records, your page numbering never tallies with my page numbering. Invariably. You set your office right,
Yes, sir, I will check it.
and that creates a lot of problem. and
Definitely,
confusion.
Definitely.
Let us read the impugned order. Are you ready?
My lord, the petitioner has already been retired, my lord.
No. Are you ready? You will not seek time, no?
No.
Then,
Lordship, I am reading the clause 3 of the impugned order.
yes.
समिति के समक्ष बताया गया है कि विश्व बैंक कर्मी निगम
No, you read it. You read full text. It is just 2-page order.
ओके लॉर्डशिप। दिनांक 13/2/2020 को प्रधान सचिव की अध्यक्षता में कार्मिक प्रशासनिक सुधार तथा राजभाषा विभाग की अधिसूचना संख्या सचेत दिनांक 13/2/15 एवं दिनांक 20/6/19 के आलोक में विभाग में अनियमित रूप से नियुक्त कर्मियों की सेवा नियमितीकरण के संबंध में हुई बैठक की कार्रवाई। संलग्न सूची के अनुसार आज दिनांक 13/2/20 को प्रधान सचिव की अध्यक्षता में कार्मिक प्रशासनिक सुधार तथा राजभाषा विभाग की अधिसूचना 13/2/15 20/6/19 बोथ आर रेगुलराइजेशन के आलोक में विभाग की अनियमित रूप से नियुक्त कर्मियों की सेवा नियमितीकरण के संबंध में बैठक हुई। बैठक में सर्वप्रथम अध्यक्ष एवं सभी उपस्थित सदस्यों को अधिसूचना के आलोक में अनियमित नियुक्ति के संबंध में प्रावधानों को विस्तृत रूप से बताया गया। समिति के समक्ष सेवा नियमितीकरण हेतु कुल 3 प्रकार के मामले को रखा गया। विभाग में अनियमित रूप से दैनिक कर्मी, संविदा, मासिक प्रवृत्ति के रूप में रखे गए कर्मी, राजकीय पॉलिटेक्निक, बीआईटी, सिंदरी एवं संविदा पे नियुक्त कर्मी, विश्व बैंक परियोजना अंतर्गत संविदा पे कार्यरत कर्मियों की सेवा नियमितीकरण के संबंध में। कंडिका 1 के संबंध में समिति को बताया कि विभाग में 5 कर्मी जिनकी नियुक्ति अनियमित रूप से हुई है, अध्यक्ष महोदय द्वारा निर्देशित किया गया है कि वैसे सभी संबंधित कर्मी नियुक्ति एवं उनकी शैक्षणिक योग्यता आदि से संबंधित सभी कागजात को पूर्ण रूप समीक्षा कर ली जाए ताकि समिति की अगली बैठक में इस मामले पर निर्णय लिया जा सके। कंडिका 2 राजकीय पॉलिटेक्निक बीआईटी सिंदरी में वित्त विभाग के संकल्प संख्या 5 दिनांक 5/7/2 के आलोक में संविदा पर नियुक्त 4 कर्मी के नियमितीकरण के संबंध में समिति को बताया। समिति का यह मानना है कि व्याख्याता के पद में नियमित नियुक्ति झारखंड लोक सेवा आयोग के अनुशंसा पर विभाग द्वारा की जाती है। ऐसे स्थिति में इन कर्मियों का मामला कार्मिक विभाग की अधिसूचना दिनांक 13/2/15 की कंडिका 3 में की गई प्रावधान के अंतर्गत अध्यक्षित प्रतीत नहीं हो रहा है। अगले बैठक में वंचित कागजातों के साथ इस विस्तृत चर्चा हेतु समिति द्वारा सहमति व्यक्त की गई। Now my कंडिका 3 is in respect to the petitioner also.
This is not in connection with the petitioner.
No, 1 and 2 is not for the petitioner. 3 is for the petitioner. समिति के समक्ष बताया गया है कि विश्व बैंक कर्मी नीलम कुमारी एवं अन्य बनामा राज्य सरकार एवं अन्य द्वारा माननीय उच्च न्यायालय में WPS नंबर 6003/17 दायर किया गया, जिनमें दिनांक 25/8/18 को माननीय उच्च न्यायालय द्वारा न्याय निर्देश पारित किया गया। न्याय निर्देश के आलोक में विधि विभाग की व्यवस्था में प्राप्त की गई जिस सेवा नियमितीकरण संबंधित नियमावली 2015 के आलोक में कार्रवाई करने का परामर्श दिया गया। इन कर्मियों वादियों द्वारा अवमाननावाद संख्या सच भी दायर किया गया, जिसमें विभाग की ओर से इस आशा के कारण कुछ दायर किया गया कि सेवा नियमितीकरण नियमावली 2015 के आलोक में इनके दावों पर गठित समिति में उपयुक्त विचार किया जाएगा। विश्व बैंक परियोजना अंतर्गत संबंधित पर नियुक्त 7 शिक्षक संविदा पर नियुक्त 7 शिक्षक एवं 65 शिक्षकेतर कर्मियों की नियुक्ति संयुक्त बिहार सरकार के विज्ञान एवं प्रबंधित विभाग के द्वारा किया गया, जिसके पद सृजन, आरक्षण, विज्ञापन, साक्षात्कार कर्मियों की नियुक्ति की गई। उपयुक्त वर्णित तत्वों से यह स्पष्ट होता है कि विश्व बैंक कर्मियों की नियुक्ति अनियमित नियुक्ति के दायरे में नहीं आती है, क्योंकि इन कर्मियों का मामला कार्मिक प्रशासनिक सुधार तथा राजभाषा विभाग की अधिसूचना 13/2/15 20/6/19 से अक्षतित प्रतीत नहीं होता है।
Were you
covered.
ever absorbed in the regular establishment of the state
That I will
government?
say in 2002.
That is the order of absorption.
Lots. Not absorbed नहीं हुए.
Absorb नहीं हुए तो फिर कैसे?
हम वो बोल रहे कि हम.
You were appointed against a project.
Against the project.
And against the project, some advertisement was made, the selection process was done, but that was for the project.
That I am submitting lawsuit. Subsequently, I have annexed all the document. In 1998, the project comes to end, and the state of Bihar took a decision. All those who are working in the project now comes to end, and the work is perennial in nature. So they all be work for the state of Bihar.
What is the date of the decision taken?
In 1998. That exact.
Where is that decision?
Lawsuit. 10/10/98.
Annexure?
Lordship may comes to my reply.
You have that is the whole problem. You annex the material documents in rejoinder and they don't have any time to respond to it. They have filed their counter affidavit.
Oh, yes, Lordship.
And you file material documents in rejoinder. And then you argue from rejoinder. They have not been given an opportunity to respond to the rejoinder. Your documents annexed with the rejoinder.
Lordship, may I come to Annexure 7, page 52, the same thing, at page 52.
This particular order of regularization or denial, was it passed after granting you an opportunity of hearing?
No. And second thing, Lordship, which I am submitting.
You see, I'll tell you one thing, Mr. Counsel.
Yes, Lordship.
In the matter of regularization, there are many things which the petitioner would like to say. You may have the last say subject to any scrutiny by the court. But if they are relying upon any document, if they are relying upon any circular, if they are relying upon any decision of the government, then that opportunity is required to be given to them.
Yes.
You pass orders of regularization absolutely ex parte. Whatever is placed before you, you pass a 2-page order.
As per the
Then let us see if they have anything, any circular they want, which all documents you want that they should have been considered. Which all documents from the records you want that should have been considered. You just give us that list. We will mention it in the order and they will pass a fresh one. You just tell us which all documents. And you claim that you have been absorbed in the state government by virtue of a decision of the state government. Where is that?
Lordship, that has also become in Annexure 7, page 52, Lordship.
The rejoinder which has been filed by the petitioner.
Where it has been stated by the state of.
Sorry?
The rejoinder which is filed by the petitioner is not.
I asked you a question at the threshold. Are you ready? You say rejoinder is not there. It has been served on you.
Also, definitely without serving to the state government, the copy will never be accepted.
It has been served on you. Of course it has been served.
ऐसा नहीं सकता है.
इनको होश ही कहाँ है? होश में थोड़ी है. नेट में चेक करेंगे तो भी पता लग जाएगा रिजॉइंडर फाइल हुआ.
Yes, sir.
We can provide you everything, but we cannot provide you diligence. Due diligence on your part is totally missing. When the case is fixed for final disposal, is it not your duty to find out from the net as to what all, whether rejoinder has been filed, not filed? You don't bother about it. Too casual about a case.
Sorry.
बताइए.
Lordship, Annexure 7, page 52, Lordship, last paragraph. विश्व संपोषित पॉलिटेक्निक शिक्षा सुदृढ़ीकरण परियोजना की अवधि दिनांक 30/9/98 को समाप्त हो गई. बिहार सरकार के संकल्प ज्ञापन 11/4/90 के अनुसार परियोजना के अधीन प्रारंभ किए गए पाठ्यक्रमों संचित उपलब्धियों के भविष्य में बरकरार रखने की राज्य सरकार की प्रतिबद्धता है, जिसके अनुसार परियोजना समिति के बाद यानी दिनांक 1998 के पश्चात इसके अधीन विभाग योजना उपयोजना के अवधि विस्तार एवं नियमित नियुक्ति की प्रत्याशा में संबंधित
This you are reading letter contained in memo number 735
2022 Lordship. It has come and we are getting salary from the treasury. I have annexed that document also. Now I am not.
You see, this particular had a list, an annexure. शिक्षक 7 शिक्षक 55 शिक्षेतर कर्मी कुल 62. Annexure A. Does your name appear in that list?
In contra affidavit also.
No. This particular document gives a
Which
list
I have
also.
annexed for my regularization.
Yes.
Haan,
See,
in
page
that
number 53.
My name is there also. Detail of employees sent for the regularization on 4/2/21, annexure 9, page 55. My name is there. My name is at page, Lordship.
It doesn't have any list.
No. My name is there that I have stated, Lordship.
Where have you stated? This circular has not been considered by them. When was this order passed?
This impugn order has been passed, Lordship, on 13/2/20.
20. And thereafter there is a decision.
Decision. Thereafter they have taken decision. And in spite of that, I made a representation on 2/3/23. They have not considered. That is annexure 16, page 95. My representation. When I got all this document, I made a representation.
You see, you have attained the age of superannuation on
that's why
28 to
Lordship-
2022. That is why your name is not there.
Lordship, also what I am saying, Lordship, that pension rule 58 and 59. 58 and
You
59.
see, the decision to regularize has taken place at a later stage. That is after your
Regularization took place after the first order passed by this honorable court.
You do not know. This particular document is talking
this
about a
particular
list,
document,
and you have
definitely.
not annexed a copy of the list also, and you are arguing on the basis of that document.
No, Lordship,
That is a
rightly
truncated.
pointed. Right.
Any document without its enclosure is a truncated document.
Lordship, I accept. I'm not saying on that point, Lordship. I'm saying.
I will ask them to take a. You just take a decision. If their name is there, their entitlement is there, you give them a hearing and pass an order. But that list is not there. I will observe that that list is not there.
Lordship.
And he has attained the age of superannuation on
On
28
28
to
to
22.
22.
If he is entitled in terms of annexure 7, then you take a call. It is your decision. Right? You want to rely on any other circular? Apart from this?
Apart from this, Lordship, I am relying upon Rule 59 with the direction, the executive order of 1969, where it says the temporary employee work under the state government, then they should consider for the retirement.
You are not a temporary employee working under the government. You are a person working in a project.
Since Lordship is reminding, I am saying they should also consider this part also. That's it. Rightly pointed out by Lordship that they should take a decision. So they should also take a decision in terms of 59.
Then I will record his submission also that you were not a temporary employee. You were working in a project.
I am reading what is the language, Lordship.
Well, in paragraph number 13 of the contract,
Yes.
it restricted matter the associated arrangement was purely temporary in nature.
In para 12 of the counter affidavit, they simply say, I cannot be regularized because I am working on a project. Lordship says that in 98 only, the project comes to end. And if Lordship sees one of the judgment, only one judgment which I have given to Lordship,
That you have to satisfy them.
That lordship.
They have taken a decision with respect to persons, and the law is also well settled that the person who is not in employment cannot be regularized.
That lordship I'm also not submitting. That's why I'm handling on 59 now. Lordship, with this issue, lordship, so far not I'm saying about the regularization.
There are direct Supreme Court judgments on this.
59 of pension rule has been considered by this.
The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel filed referring to the impugned order, refusing to grant the benefit of the petitioner of regularization in terms of circular number 1348 dated 13/2/2015, read with circular number 4871 dated 26/2019, has submitted that the impugned order has been passed on, what is the date? 13/2/2020, and there has been a subsequent decision of the state government as contained in Annexure 6, Annexure 7 to the writ petition by memo number 735 dated 10/8/2022. The learned counsel submits that the said decision is in favor of the petitioner and if the respondents are directed to consider the said decision along with other applicable rules and regulations, the petitioner would be entitled for regularization in terms of the said circular. The learned counsel further submits that after the issuance of the said circular, the sole petitioner.
This is sole petitioner.
Sole petitioner has represented before the respondent number.
Number also. Director Technical Education 5. That is respondent number.
Respondent number 6.
6.
Before the respondent number 6. But no decision has been taken. The learned counsel has further submitted that the claim of regularization of the petitioner has been rejected by the impugned order without granting any opportunity of hearing to the petitioner, and consequently other material facts which was required to be considered by the authority could not be placed. Is that correct?
Yes. Because after rejection on 4/2/21 before my retirement, though that is my fault, lordship, except name of regularization of the list of person name for regularization has been sent by an action manner.
The learned counsel has also submitted that the learned counsel submits that one opportunity be given to the petitioner so that the case of the petitioner be considered afresh in terms of the aforesaid circulars. The learned counsel has further submitted that the petitioner is concerned only with paragraph number 2 of the impugned order, paragraph number 3 of the impugned order. So far as paragraph number 2 is concerned, it is relating to some other employees. The learned counsel appearing on behalf of the respondents has opposed the prayer and has submitted that the petitioners were appointed contractually to the post of programmer in the year 1996-97 on consolidated monthly emolument for a specified period of minimum 1 year and maximum 3 years by the government under World Bank aided strengthening of polytechnic project initiated in the year 1990-91 by the undivided state of Bihar. In course of time, the government, through resolution number 971 dated 11/4/1990, had resolved to continue the courses, and the period of contractual employment of the petitioner was extended till 30/9/1998, when the World Bank aided strengthening of polytechnic project came to an end. The last extension was given by the state of Bihar after bifurcation, white letter dated 17/2/2021 till 28/2/2021, and ultimately from 1/3/2021 till 28/2/2001, and ultimately from 1/3/2001, the contractual service of the employees of World Bank aided strengthening of polytechnic project came to an end. The state of Jharkhand took a decision in 2003, being a welfare state, allowed the petitioner along with several other similarly situated contractual employee of World Bank/aided project schemes to continue in the employment in the same terms and conditions of contract as agreed by the parties until the regular and substantive appointment would not be made against sanctioned post. It is their further case that the arrangement was purely temporary in nature, only to provide means of livelihood to the contractual employee who were on the verge of retirement. It has been further asserted that on 28/2/2022, the petitioner is not in service after attaining the age of superannuation, after attaining the 60 years. The Learned Council submits that in view of the Learned Council further submits that there is no question of payment of any post-retirement benefits to the petitioner, as the petitioner was never employed in service of the state government on regular basis. However, during the course of argument, it is not in dispute that the impugned order has been passed without giving an opportunity of hearing to the petitioner, and after the impugned order, a decision has been taken contained in memo number 735 dated 10/8/2022. Though the enclosures or annexures to the said decision has not been annexed by the petitioner in this petition, and therefore it is not known as to whether the name of the petitioner appears in the said list or not. It further appears that the petitioner has annexed a few more documents along with the rejoinder to the counter affidavit, to which the respondents had no occasion to respond. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that the petitioner was employed by virtue of a tripartite agreement dated 11/4/1990, executed between the Ministry of Human Resource Development, Government of India and Government of Bihar and International Development Association World Bank for running a program in the state of Bihar for strengthening the polytechnic education, which was under the implementation by the then state of Bihar. It further appears that the service of the petitioner was continued from time to time under the said project, though on contractual basis, but and even after the end of the project, the petitioner was permitted to continue. By virtue of certain decision taken by the state of Jharkhand in the year 2003.
Annexure 8 After working under the state, extension was given in 2006 by the state.
Refer only undisputed facts. Ultimately, the petitioner attained the age of 68 years on 28/2/2022. It further appears that certain decision was taken in connection with the employees of World Bank, in connection with the persons employed in the project by virtue of decision contained in memo number 735 dated 10/8/2022. But the enclosures to the said decision has not been annexed. This court further finds that the impugned order was passed on 13/2/2020 and therefore there was no occasion to consider the aforesaid decision dated 10/8/2022. It further appears from the records of this case that the petitioners are claiming regularization strictly in terms of the aforesaid circulars issued in the year 2015 and 2019. And the impugned order has been passed without granting an opportunity of hearing to the petitioner. This court is of the considered view that the claim for regularization of the petitioner has a serious bearing on his right to life and personal liberties, and such denial cannot be taken lightly. In such circumstances, this court is of the view that in order to reject the claim of the petitioner for regularization, an opportunity of hearing was required to be given to the petitioner so that the entire facts which is sought to be placed on record in this writ petition could be considered. In order to enable the respondents to pass a fresh order after granting an opportunity of hearing to the petitioner, the impugned order dated 13/2/2020, so far as it relates to the petitioner in paragraph 3 thereof, is hereby set aside, and the matter is remitted to the respondent number
6 Lordship, and
Yes.
6 will
place it before the committee.
before the committee. And all.
Respondent number 6 to enable the petitioner to file their detailed representation, to file his detailed representation by giving each and every fact with regard to his service, along with supporting documents, including the enclosure to the Annexure 7 dated 10/8/2022, along with a copy of the writ records. The respondent number 6 shall grant an opportunity of hearing to the petitioner and draw an order with regard to the claim of the petitioner, and thereafter place the records before the committee who has passed the impugned order, so that the claim of the petitioner is taken to its logical end.
Any time frame?
The needful be done by the respondent number 6 within a period of 2 months from the date of the presentation, and the final decision be taken by the committee within a period of 4 months from the date the matter is placed by the respondent number 6 before the committee. This writ petition is disposed of with the aforesaid observation and direction. The reasoned order to be passed by respondent number 6 as well as the final decision of the committee be communicated to the petitioner through speed post. It is made clear that this court has not entered into the merit of the claim of the petitioner, and the impugned order has been set aside so as to enable the petitioner to place his entire case before respondent number 6 and before the committee through respondent number 6.
Item 5, WPS 2133 of 2023.
Petitioner has come before the Supreme Court against the punishment order at Annexure 6 as well as the appellate order at Annexure 7 of the petition. However, the departmental proceeding has been initiated under Rule 17 of the CCA rules, Your Worship. But several provisions contained in the rules, Your Worship, procedural rules, Your Lordship, has been not complied by during the departmental proceeding, Your Lordship, and the punishment order has been passed in.
What was the allegation against you?
Allegation, Your Lordship? Allegation were charge were framed in 3 stages, Your Lordship. In March 2020, in March 2020, 3 charges were framed, Your Lordship. Thereafter, it was.
I want to know what was the allegation against you.
Allegation, Your Lordship, allegation. Several charges are there, Your Lordship.
Pleadings are complete.
Altogether, Your Lordship. Altogether
Admit.
five charges.
Rule returnable 6 months.
Your Lordship.
We'll admit and hear it. You are not ready.
Your Lordship, altogether 5 charges are there, Your Lordship. How can I?
We will hear it. We are not
how
dismissing
can
your. We are admitting
Your
it.
Lordship, it
Rule
will
is
take-
returnable within 6 months. I will fix a date also. You choose your date. The basic question is what was the charge?
Your Lordship, charges are not one, Your Lordship. There are 5 charges, Your
But
Lordship.
main charge
How
is
can,
always
how
there.
can I say in one line, Your
No
Lordship?
problem. We are admitting it. We are not dismissing
Your
your
Lordship,
case.
Your Lordship, it is
Just
the-
6 months.
Your Lordship, 6 months is.
You wait for it. It's not too much. In a departmental proceeding where there are concurrent findings, we have to scrutinize many things.
Your Lordship,
You have
appeal order
filed.
may kindly be seen, Your Lordship. It has been passed by the authority who has passed the punishment order.
We will see that. We are
Your Lordship,
posting
say
it on.
6 months will be very
We
harsh to
will-
the petitioner, Your
Not
Lordship,
at all.
because-
It is not harsh.
Because, Your Lordship, his promotion is being kept pending, Your Lordship. He is compelled to work under his junior, Your Lordship.
We will see that. We will see.
Your Lordship, the date may be given in.
I'm giving you it.
Not beyond 6 months, Your Lordship. I'm just praying, Your Lordship. However, I have given list of dates, Your Lordship, and it is not so that I am not ready, Your Lordship. List of judgments, list of dates, short synopsis of argument, everything I have given, Your Lordship.
Post rule returnable on 6th August. 6th August.
6th August, Your Lordship, it will be very harsh, Your Lordship. Your Lordship, any earlier date will be given, Your Lordship. I shall be obliged.
6th August is prior to expiry of 6 months. Did you realize that?
August, Your Lordship, it is March, Your Lordship, August is, Your Lordship.
Then I will just keep it like this. You file your application for early hearing. That would be better. Isn't it? This is the earliest I can. It requires a lot of. I have seen the records. Do you think that I am not ready or do you? Do you have any such idea? No.
No, Your Lordship, just
It requires no.
Your Lordship.
I have
Nothing
already
more
given an
than
early
that,
date. Call the next case, please.
Item 6, WPS 2606 of 2023.
Yes, petitioner.
On the last date, the Lordship was pleased to grant a stand to file rejoinder to the counter affidavit. Although, Your Lordship, after the retirement, the petitioner has moved to a different place and for procuring some documents, and due to the reason she could not come to sign the oath. The question was some time.
What is the matter?
Your Lordship, it pertains to payment of pension, Your Lordship.
What is it in the counter affidavit which you want to respond?
Your Lordship, initially the petitioner.
What is there in the counter affidavit which you want to respond?
Your Lordship, may see page 10 and 11 of the counter affidavit. Para 10, Your Lordship, of the counter affidavit.
You read para 10?
It is most strongly and respectfully stated herein that pursuant to annexure 3, appointment letter of the petition, it is obvious that in compliance with the departmental order issued by the principal secretary by Governor such and such, and the order given by Deputy Commissioner cum Chairman, District Education Establishment Committee, therefore the petition is appointed by the competent authority and appointment letter is issued by memo number 1649 dated 23/11/2000.
Is there any grievance against this?
No, Your Lordship, this has been.
Proceed further.
Your Lordship, primarily we have filed. Your Lordship, we come to annexure 3, page number 23 of the writ petition.
Are you disputing this fact mentioned?
No, Your
in
Lordship,
this one?
we have mentioned this in the writ petition. And
That's
this,
okay. So it's an admitted fact.
Yes, Your
You don't
Lordship.
need to rejoin to this. You have to file a rejoinder to a disputed fact which has been raised in the counter affidavit. So I want to know that where is this dispute?
There is no dispute as such.
Then why do you need a rejoinder?
Your Lordship was.
If there is no disputed fact mentioned in the counter affidavit, why do you need to give a rejoinder? Is there anything new in the counter affidavit which has not been mentioned in your writ petition? Is there anything which is contrary to whatever you have stated in your writ petition? Pleadings are meant to controvert the statements made in the counter affidavit, isn't it? Yes.
Your Lordship, on 18.
From the date of joining, they say that you have entitled to everything. You attained the age of superannuation on 31/12/2021, and all retirement benefits have been paid to you.
Your Lordship, the result for the JPSC through which I was appointed was out on 18/8/2005. Thereafter, Your Lordship may see page number 22 of the writ petition.
It was published on
18/8/2005.
Okay. Then what happened?
Your Lordship may see page number 22 of the writ petition, Your Lordship.
Then what happened?
And Your Lordship, a letter was sent from the Sachiv to the Jila Sikshak Adhikshak, wherein it was stated, Your Lordship, that I was recommended to be posted in this letter, Your Lordship.
Which letter?
Annexure 3 series, Your Lordship.
What is the date of that letter?
Your Lordship,
And
is
give me the
20
page number. There has to be only one letter, isn't it?
Yes, Your Lordship. The date is 26/5/2008.
Annexure.
Annexure 3 series, Your Lordship, page number 22 of the petition.
This concerns you?
Yes, Your Lordship. निर्देशानुसार उपर्युक्त विषय के संबंध में सूचित करना है कि प्राथमिक प्रशिक्षित शिक्षक नियुक्ति हेतु आशा प्रकाश रोल नंबर दैट इज द पिटिशन, योर लॉर्डशिप, सामान्य जिला देवघर के लिए आयोग द्वारा अनुशंसा प्रेषित की गई थी आपके पत्रांक सच के द्वारा. So your lordship, after this we had to
Within 6 months you were to be appointed.
Yes, your lordship. Now your lordship may see annexure 1, your lordship.
No, what happened thereafter? Give me the sequence. What happened thereafter?
Thereafter, your lordship, we filed a writ petition.
When did you file the writ petition? You were not permitted to join.
No, your lordship.
What is the writ number?
Your lordship, annexure 1 is the order of the writ petition, your lordship.
What is the year of the writ?
3263 of 2007.
That was prior to this issuance of this letter.
Yes, your lordship. After the order of the writ petition, the last paragraph, the operative part of the order reads, considering the peculiar facts and circumstances of this case, this writ petition is being disposed of by directing the respondent UPSC to consider the case of the petitioner for her being appointed as primary trained teacher in the district of Devar as early as possible, preferably within a period of 6 weeks from today. Thereafter, your lordship, the
That's
petitioner.
right. So pursuant to this order only, this was passed on 14/3/2008.
Yes, your lordship.
Pursuant to this order, then this letter was issued. Dated 26/5/2008.
Thereafter, the petitioner had to prefer a content petition also. The next page.
That's right. Okay.
And
So
after
then
that-
ultimately this letter was issued.
Yes, your lordship.
What happened after 26/5/2008?
Now, your lordship may see page number 23, your lordship. After the recommendation was made by the JPSC, the state government has given me the appointment in the year 2013, after a lapse of 5 years, your lordship. The date is 23/11.
There was an appeal filed, 297 of 2013. What is this LPA number 297 of 2013?
That was filed by the state, your lordship, but that was dismissed as
Who
per-
filed it? You were the party in that?
Yes, your lordship.
ये जरा LPA का जिक्र LP number 297 of 2013. 297 of 2013. This was filed by the state against which order?
The order of the contempt, your lordship.
The order of the contempt. When was the order of contempt filed? Passed? Where is the order of contempt?
Annexure 2, your lordship.
Annexure 2. saying that order has already been complied.
Yes, Your Lordship.
And ultimately, you were given appointment on, by virtue of this letter, 23/11/2013.
Yes, Your Lordship.
Right?
After 5 years, Your Lordship.
When did you join?
Your Lordship, I joined on the 2nd of December 2013.
What do you want?
Your Lordship, we are seeking pension benefits for the period that has lapsed due to the department, Your Lordship, the defect, the.
You want retrospective date of joining?
Yes, Your Lordship. There are some case laws also, Your Lordship.
What is the case?
This is a compilation of.
Whenever you cite any judgment from any other high court or even from this court, you should always check whether it was subject matter of appeal before Supreme Court or not.
Yes, Your Lordship.
Have you checked it?
Yes, Your Lordship. I've checked.
Any order
Yes, Your Lordship.
affirmed?
No, Your Lordship. These government of West Bengal went to the Supreme Court, but that order was that SLP was dismissed.
Where is that order? And which order was subject matter of consideration by the Supreme Court? You have annexed with this?
No, Your Lordship. Not in the compilation, Your Lordship. The compilation is a set of 3 judgments, Your Lordship, which have been held to be valid year after year, Lordship. In 2016, 2018, and thereafter in 2023 as well.
You see, in one of the cases which you have cited, there was a direction of the High Court to give appointment. Is there any direction of the High Court to give appointment? In your case?
Your Lordship, my case was to be considered as per the
So
order.
there was no direction to give appointment.
But
There is a
thereafter-
difference between the two.
But thereafter, Your Lordship, the notification has been issued by GPSC.
That's right. Must have been. There are two things. When the court directs that you appoint within 15 days, and the respondents do not act pursuant thereto,
Even if
then some benefit can be given to you to relate back the.
Even if, Your Lordship, the order of the High Court is not to be considered, the recommendation by the JPSC may be considered, Your Lordship.
That's right.
That pertains
We
to
will
the-
consider. Don't worry about it. That's your only grievance?
Yes, Your Lordship, the pensionary benefits.
And otherwise, the pensionary benefits have been given to you, taking your date of joining as the.
No, Your Lordship, since there is a rule that 10 years of service should be completed, I have not completed 10 years of service, so I claims for this period to be considered. Thereafter, my 10 years of service will be considered and pension will be automatically.
But they say that the pensionary benefit has been paid. They have stated that pensionary benefit has been paid. Maybe some post-retiral benefits. All retiral benefits has been paid. Maybe that you are not entitled to pension, but you might be entitled for other relief. Yes, what do you say, respondent?
But our stand in the counter to it, that can be considered.
They are governed by Jharkhand Service Code.
Joining made in the year of 2013. Thereafter, she continued in this.
They are governed by Jharkhand Service Code. There is a provision in Jharkhand Service Code that salary will commence from the date of joining only. Isn't it? You are not aware.
Not aware exactly.
Right.
But the Lordship kindly consider how the petitioner can claim any benefit when she has not born in the cadre.
That's right.
And my lord,
Learned counsel for
earlier
the
read
parties
petition
are
also, my
present.
lord, there is no direction, my lord, to give any benefit with regard to earlier period, my lord. And she only after retirement raising claim.
Your Lordship, that is because the
So, my
cause
lord,
of
there
action
is
has arisen.
a delay latches also, my lord, on part of the petitioner, my lord, in raising her claim. My lord, even, my lord, the right cannot be enforced, my lord, after such a long delay. Even if it is assumed that any right has been violated, that cannot be enforced, my lord, after, my lord, more than, my lord, 10 years.
That's right. I'll have to go through these orders. I will dictate in the second half. Let me just go through these orders, whatever you have cited.
Your Lordship, one small submission, Your Lordship. We have already made various recommendations. We have made various, we have written a lot of times to the concerned authorities, Your Lordship.
I have heard you. Now there is no question of disposal of this. We are not interested in generating litigation. Right? 4 o'clock. इसके पीछे कर देख के ऑर्डर कर वो चेंबर में
Refer one judgment, my lord, with regard to, my lord, enforcement after much delay, my lord. Enforcement of any right, my lord, after much delay is not maintainable. May I refer one judgment, my lord?
You refer it. You give the citation.
2020, volume 1, JLJR.
You give the citation. Slip में दे दीजिए.
There.
मंगा लीजिए. Next call करेंगे. 4 बजे के लिए. क्या 4 बजे के लिए क्या? देखिए. We'll take this matter at 3:45. We have already a matter fixed at 4 o'clock. ये 4 बजे वाला फाइल दीजिएगा. नहीं देगा.
Item 8, WPS 4638 of 2023.
This petitioner.
Lordship, by last order, there was a direction to file rejoinder, Your Lordship. We need 3 weeks time to file rejoinder, Your Lordship, because there has been a casualty in the family, Your Lordship. Therefore, petitioner could not affidavit the rejoinder, Your Lordship. As a matter of last indulgence,
Learned counsel for the parties are present. Counsel for the petitioner prays for and is granted. How much time do you need?
3 weeks, Your Lordship.
There is a casualty in the family of the advocate on record. Mr. Manoj Tandon.
Petitioner, because it could not be affidavit, Your Lordship.
Counsel for the petitioner prays for and is granted time till 1st April to file a rejoinder to the counter affidavit. Post this case on 24th April by way of last indulgence.
दोनों का नाम. Item 9, WPS 6259 of 2023.
In this case, I was supposed to file a counter affidavit with the supplementary affidavit. I have sought instructions from the SSC, it has not yet come, I pray for some more time.
How much time do you need?
4 days.
So it is a appointment matter and initially also.
Actually, JSSC at the moment is in turmoil with this, so much of inquiries going on with this. Have you occupied the medicine also? Otherwise, I would not have asked for it.
Earlier also I said that they will say later on, they will say that now everything is over.
It can't become over once that
No,
is
it
pending.
will not become over. And
It cannot become over like this. By way of last indulgence.
Yes, certainly. I called them, they
Otherwise-
said at the moment, the
Shorter
Home
date.
Office is in, special investigation team is sitting throughout the day.
The learned counsel for the parties are present. The learned counsel for the respondent JPSC.
It's JSSC, Jharkhand
JSSC, respond number?
Jharkhand Staff Selection.
Respondent Jharkhand Staff Selection Commission. Respond number 3 कर दीजिए. Respondent number 3 prays for and is granted time till 1st of April 2024 by way of last indulgence to comply with the order dated 13/2/2024. Pose this case on 3rd April. आप लोग कोई ऐसा रेजोल्यूशन पास करिए कि छुट्टियां खत्म हो जाए, तभी हो सकता है. वी हैव होली ब्रेक.
नहीं, हम उसके लिए नहीं कर रहे, हम तो यही करेंगे, इनको करना चाहिए था. तो इनिशियल रिट पिटीशन का ही पॉइंट है.
उन लोगों को जो जो करना चाहिए था कर ही देते, तो हम लोग क्या करते? कुछ नहीं करते.
वही शॉर्टर डेट दे करके.
That is the shortest possible date we can think of at this point of time. We have an intervening break for him. 1 तारीख को नहीं फाइल करेंगे ना, Mr. Singh.
Yes.
I will impose very heavy cost on you, and I will not even grant further
It may be
return.
noted कि ये
I have
decide हो
already
जाएगा.
stated.
It
By way
will
of
be
last
decided.
indulgence.
It will be decided that.
Yes, yes, it will be decided on the basis of materials. We will not grant further indulgence.
Item 10, WPS 7588 of 2023.
Obliged.
Yes, petitioner.
Party directed.
They have not filed their contract. WPS, why don't you file contract with the
Because we have received the statement of fact notice in a week notice.
What does your statement of fact say?
The office today itself we have received.
Okay, you file it by next week. It's a matter of compassionate appointment.
Yes.
The counsel for the parties are present. Counsel for the respondents pray for and is granted time till Monday to file the counter affidavit in the present case. Hold this case on 13th March.
For fresh filing, item 11, WPS 4424 of 2023.
The petitioner is giving for compassionate appointment to that to death of his father.
What is the date of death?
It is in the year 2008.
2008.
2008. I will not be stricken by the limitation clause as I applied on the same date. They rejected me once. I came before this honorable court. The honorable court quashed that rejection order and remitted the matter.
Let me know the date of death.
The date of death is 14/7/2008.
It was rejected when?
It was rejected in the year 2016, which is at Annexure 9. Which is at page 36. In the year 2016, it was rejected.
Give me the date.
Page
number?
It is page 36, Annexure 6, 10 to 2016.
Then this was set aside.
This was set aside.
In WPS number?
In WPS number 981 of 2018, which is at Annexure 8, page number 40. And the matter was
Annexure 8.
The matter was remitted back to the authorities for fresh consideration.
What was the earlier ground of rejection?
The earlier ground of rejection was on twofold. One, I was non-matriculate.
Yes.
And leadership will see and I was non-matriculate, and the school which I studied from was not a recognized one. It was the contention before this honorable court in the earlier writ petition that the condition that the applicant should be a matriculate was imposed only in the year 2011, whereas the death of the father of the petitioner happened in the year 2008, immediately after the application was made, and it was the respondent who kept the petition pending, and on that ground that matter that was paused, set aside and remitted back to the authority.
What is the fresh ground?
Fresh ground is nothing. They have stated that since it was considered earlier, it requires no consideration. This is the audacity of the authority. Leadership may see annexure 10 where we have action.
Where is the fresh order?
Leadership, it is that is annexure page 10, page number 53, Lord, you can see, Shri Amit Lohra. At relevant is at page 53, serial number 19.
Kindly read it.
उक्त मामले पर पूर्व में ही माननीय न्यायालय द्वारा WPS नंबर सच एंड सच पर पारित आदेश के आलोक में जिला अनुकंपा समिति द्वारा पुनर्विचार किया गया था। समिति के समन्वयक विचारोपरांत और स्वीकृति का निर्णय यथावत रखा गया। अतः परिजक के बारंबार अनुरोध के सहानुभूति विचार करते ही उक्त मामले के विभाग से उक्त मार्गदर्शन मांगा गया था। विभागीय मार्गदर्शन वाद संख्या सच में पारित आदेश के आलोक में न्यायानुसार कार्रवाई करने उल्लेख है। अतः उक्त मार्गदर्शन के आलोक में वर्तमान में जिला अनुकंपा समिति सामायिक विचारोपरांत इस निष्कर्ष में पहुंचती है कि प्राप्त मार्गदर्शन पूर्व में
Where is the earlier decision? Where is the decision which is being referred to in the implement?
They have annexed it.
That is at
page 40.
Page 44, starts at page 44. That is the
No. They say that pursuant to the order of the court, a decision was taken.
Ladies, you will see page 45. The relevant part is at page 45.
Yes.
Bottom of.
At the entry number 34, दिनांक सच एंड सच के 124वें जिला स्तरीय अनुकंपा समिति की बैठक में आवेदक द्वारा समर्पित अष्टमोत्तीर्ण शैक्षणिक प्रमाण पत्र निर्गत करने वाली संस्था के द्वारा मान्यता प्रदाता नहीं रहने के कारण आवेदन का अस्वीकृत किया गया था। उक्त निर्णय में के आलोक में आवेदक माननीय उच्च न्यायालय के WPS नंबर 981 ऑफ 2018 बाद दायर किया गया, जिसके विरुद्ध कार्यालय स्तर में पुनर्विचार करने का निर्देश प्राप्त हुआ। उक्त आलोक में समिति द्वारा पूर्व में लिए गए निर्णय को ही यथावत रखा गया। Even after the quashing of the
What was the minimum qualification as per the earlier circular? Where is that circular?
That earlier circular, ladyship, there was no educational qualification.
Where is that circular under which you are claiming? You say that 2000 circular will not apply. Fair enough.
2011 circular.
Yes. 2011. Where is the circular on the basis of which you are claiming compassion?
That particular circular is not on record. I'll bring it on record. However, ladyship, my claim before your ladyship is once this honorable court quashed the reasoning of the authorities and remitted the matter back, and the authorities.
There is no fresh decision after the passing of this order?
No, that is what they have said, ladyship. I was reading.
Is that so?
My lord, that is so. They had come to me with a statement of facts. I sent it back. I told them that because this happened just yesterday.
You have not filed your contract?
No. They came yesterday with a statement of facts. I can't find. This is the first time order for counter has been given.
WPS number 4424 of 2023. The learned counsel for the petitioner submits that the father of the petitioner expired on 14/7/2008, and the matter regarding grant of compassionate appointment was rejected only on 10/2/2016 on two grounds, namely that the petitioner was non-matriculate and that the school from which the petitioner had studied was not recognized by JAC. He submits that the said order of rejection was challenged in WPS number 981 of 2018, and the order of rejection was set aside and the matter was remitted to the authorities for fresh consideration by order contained in Annexure 8 dated.
There are two orders.
Date of High Court's order.
2021.
Date of High Court order.
High Court order. Leadership, the High Court order is dated 4/2/2021.
4/2/2021. The learned counsel submits that thereafter the fresh order only indicates that they had taken a decision earlier and therefore no fresh decision is required to be taken. Counsel for the respondents is directed to seek instructions and file a counter affidavit in this case which should specifically enclose the decision which has been taken by the respondents after the order passed by this court. Let the counter affidavit be filed by 1st April.
My lord, some time may be given. They'll have to reconvene the meeting. I was not satisfied with my planned steps, so they'll have to go through the entire process.
Then you have to simply say that you want to reconvene the meeting. We will set aside the
My
order.
understanding is that.
We will set aside this order to facilitate
No,
your reconvention now.
No, that's not required at this stage, Your Lordship. They have to comply with the.
Suppose there is an order which is standing. Then under such circumstances, if you say that no fresh order was passed.
No, fresh order was passed, but that order is not a proper order, Your Lordship. As per, there was a specific direction by this order.
It says that they have already taken a decision. Which decision are they referring?
My Lord, I will explain, Your Lordship.
You file your counter.
Let me be permitted.
You don't need, you see, when things are already on record, there is no question of, looking for it anywhere. If it is not there, you just file a counter affidavit that it is not there. We'll ask you to pass a fresh order.
Right.
Simple.
Right.
By 1st of April, rejoinder if any by 8th April, post this case under the heading for final disposal on 9th of April. And you should also bring on record the circular by which the petition is governed. The counsel for the petitioner undertakes to file the copy of the circular under which the petitioner is claiming compassionate appointment.
Item 12.
And also the subsequent circular of the year 2011 by which the minimum qualification of metric has been introduced. You file both the circulars.
Item 12, WPS 6320 of 2023.
In this case, in view of previous order dated 29 months, the supplementary affidavit is ready, but it has not been filed in time.
Yes, what is your supplementary affidavit filed?
That is with respect to the status of the father of the petitioner as well as some documentary evidence regarding the notification as to whether the grandson is entitled for the post of Chowkidar or not on the basis of.
Chowkidar?
Yes, Chowkidar.
Hereditary right? They are claiming hereditary right or compassionate appointment?
On the basis of compulsory basis.
Take it on record. Let's have a look at it.
And so far the status of the petitioner, the father of the petitioner is concerned that we have stated in paragraph 2 of this supplementary affidavit. And so far the grandson's entitlement of grandsons is concerned. I have annexed it at page 6 and 7.
What is page 6?
It was a notification issued by the secretary to all the concerned DC members, wherein it has been stated कि विभिन्न जिलों से यह पत्र प्राप्त हो रहे थे कि चौकीदार के पद पर कोटा को नियुक्ति नामित किया जा सकता है अथवा नहीं। इस पर राज्य सरकार द्वारा संयम विचारोपरांत यह निर्णय लिया गया कि किसी चौकीदार वफादार के दिनांक 1/1/90 के बाद अवकाश प्राप्त करने पर उनके नामित के रूप में पुत्र के पुत्र पोता को भी चौकीदार के पद पर केवल एक बार अपवाद स्वरूप बॉन्ड लेकर नियुक्त किया जा सकता है।
This is basically the claim of hereditary right.
Not for that manner, sir.
Yes, yes.
Not for that.
This is not compassionate appointment. This is hereditary right.
It is for once in a time manner by taking certain bonds.
This is not compassionate appointment.
And
this is hereditary right. And that hereditary right has already been taken away by the orders of this court. Chowkidar appointment cannot be made for hereditary right.
But this is their matter, sir. And
There means what?
One more
No.
notification is of 2011 matter, sir. It is at next page matter, sir.
Yes, read it.
Para 2. गृह आरक्षी विभाग के परिपत्र संख्या 100 द्वारा आश्रितों में अगर बेटा बेटी न हो तो उसके नॉमिनी में से एक को बॉन्ड लेकर अपवाद स्वरूप भतीजा या नाती को नियुक्त करने का प्रावधान किया गया था। इसके अतिरिक्त परिपत्र संख्या 20/12/95 द्वारा मृत दफादार के आश्रितों में विधवा पत्नी, पुत्र, पुत्री या भतीजा या भाई या नाती को भी अनुकंपा के आधार पर चौकीदार के पद पर नियुक्त करने का प्रावधान किया था। So by taking into this consideration,
this circular is of state of Bihar,
it is
issued in the year 2011. It is referring to various other circulars.
other circular regarding 91, 94.
So where are those circulars?
That we are unable to obtain that circular that has been mentioned in this present circular.
You have not filed your counter. The learned counsel for the. And what have you stated about the dependency?
That we have stated in para 2 minus. That his father, namely Ravindra Kanti, is not eligible for the post of Chowkidar as he has not graduated, having no requisite qualification, and moreover he is medically unfit. As since last numbers of years he is unable to move elsewhere due to fracture of his left leg, and even not continue stable in his standing position.
Further. Another son of the deceased employee also requested and submitted application for appointment.
And I have no objection. And recommendation was also made by the concerned officer in charge as well as
You produce all the circulars and clarify whether the claim of the petitioner is by virtue of hereditary right or he is claiming by virtue of compassionate appointment. This is very important. And the circulars which governs the petitioner, what is the date of death?
that is
9/12/2014. 2014, right? A supplementary affidavit has been filed by the petitioner, which is taken on record. The learned counsel for the respondents is directed to seek instruction and file a counter affidavit in the present case. The matter relates to grant of appointment to the grandson of the Chowkidar. It is not clear from the records as to whether the petitioner is claiming compassionate appointment or he is claiming hereditary right, as was the situation prevalent earlier. The hereditary right of Chowkidar has now been taken away by various judicial pronouncements. Counsel for the respondents is directed to seek instruction and file a counter affidavit in the present case, taking into consideration the aforesaid observation made by this court, and also bring on record the circular of the state government on the basis of which the petitioner being the grandson would be entitled for compassionate appointment. Or the circular which governs the field of compassionate appointment in the matter of services under the state government. And indicate as to whether the petitioner being a grandson comes within the meaning of dependent. डिपेंडेंट में देखिए क्या क्या है, पत्नी नहीं है सर, आश्रित माने जाएंगे, पत्नी, पति, पुत्र, विधवा, पुत्रवधू, अविवाहित विधवा, तलाकशुदा, दत्तक पुत्र नहीं है आपका नाम एज पर दिस सर्कुलर.
सेकंड वाला कॉलम में सेकंड कॉलम
में क्या है? पति पत्नी,
विधवा पत्नी, पुत्र पुत्री या भतीजा या भाई या नाती को भी अनुकंपा के आधार पर चौकीदार के पद पर
नहीं वो छोड़ दीजिए आप सर्कुलर फॉर कॉम्पैशनेट अपॉइंटमेंट में आइए, उसमें आपका नाम नहीं है।
हाँ, उसमें ऐसे नहीं है।
तो कॉम्पैशनेट अपॉइंटमेंट के सर्कुलर से नाम चलेंगे।
तो that's why my lord, a general notification has been issued by the secretary to government of Jharkhand, my lord, in the year 2009.
That those days are over. Those days are over. You are claiming hereditary right by terming is at compassionate appointment. The counter affidavit be filed by, I tell you who will file the counter affidavit. कौन सा डिपार्टमेंट है ये? पुलिस?
पुलिस होम।
You have not made appropriate. These persons are not entitled to file an affidavit in the court. No, they are not supposed to. Secretary level persons are supposed to file counter affidavit. Secretary or under secretary. There is an order of the division bench to this effect.
I will make this.
You make who would be the party? The secretary. Secretary of which department? Let the secretary, Department of Home, State of Jharkhand, be made party respondent number 8 in the present case. The affidavit should be filed by the newly added respondent. The affidavit be filed by April 4th, right? To the writ petition as well as supplementary affidavit. Post this case on 9th April under the heading for final disposal. Next.
My lord, in next case, I have to file reminder, my lord, 2 days before I have received.
Item 13 LPS 7114 of 2023.
The matter relates to appointment, my lord, on contractual basis in
Lordship, before Lordship, the counter has been filed, but one thing has been missing in this counter, Lordship. I acknowledge this. So sometime maybe we will Lordship, because as per ladyship's query, they have not replied regarding advertisement issued on 2016, Lordship.
matter relates to 2016 advertisement, my lord.
WPS number 7114 of 2023. Counsel for the parties are present. Counsel for the respondent submit that although a counter affidavit has been filed in the present case, but for proper adjudication of the present case, he may be permitted to file a supplementary counter affidavit. Let the supplementary counter affidavit be filed by 1st April. Okay. Upon filing of the supplementary counter affidavit, the petitioner shall file, the petitioner, if so advised, may file a rejoinder to the counter affidavit as well as supplementary counter affidavit by 10th of April. Post this case on 15th of April under the heading of final disposal. Fresh filing to matters.
What's your admission?